Hello students. Now we can have a discussion on the key amendments which are applicable for your June 2026 examination. So as I usually mention, I have included all the amendments which have taken place a couple of years back also, so that the students who are writing the examination after a small gap will also be benefited. Okay, so we can move to the amendments one by one. So the first amendment is related to your definition of MSME. So please note that this amendment has taken place on 1st of April 2025. So we know that the MSME classification, micro, small, medium enterprises classification will be on the basis of your investment in plant and machinery or equipments and annual turnover. So with respect to micro, the threshold is like not more than 2.5 crore and not more than 10 crore, not more than 25 crore and not more than 100 crore. For medium, it is not more than 125 crore and not more than 500 crore. Okay. Then with respect to the registration of asset reconstruction company, the amendment is related to the minimum net own fund requirements. So when you are going through the provision of section 3 of Sarfasi Act, you can see that the minimum net on fund requirement is rupees 2 crore. It has not changed, but there is a provision like rupees 2 crore or such other amount as may be prescribed by RBI from time to time. Okay, so RBI has prescribed different amount at different point of time. Now the amount is rupees 300 crore, and which has given, RBI has given or issued a circular to all existing asset reconstruction company that they have to comply with the provision of 300 crore by 31st of March 2026. Okay, so the minimum net on fund requirement will be 300 crore or above. Okay, so the various compliances was by 31st of March 2026, every ARC, existing ARC should have minimum NOF of 300 crore. So in Competition Act, there is change with respect to threshold of combination, exclusive dealing agreement. The term exclusive supply agreement is now changed to exclusive dealing agreement, which is respect to your types of anti-competitive agreement. Okay, there is no change in the definition. The meaning remain the same, but only the term has changed. Okay, then appreciable adverse effect on competition, certain words have been omitted. So first we will move to the threshold of combination under section 5. We know that combination, the discussion can be grouped into two heads. Whether the enterprises are having assets and turnover only in India, or if they any of the enterprise is having assets or turnover outside India. Okay, if it is outside India, the threshold will be in USD. Okay, so if they are having, if all the enterprises are having assets and turnover only in India, with respect to the individual enterprise, it is 2,500 crore, more than 2,500, more than 7,500 turnover. It was 2,000 and 6,000. Now it is changed to 2,500, 7,500. With respect to group, more than 10,000 crore or more than 30,000 crore. Okay. In the other category, outside India category, more than 1.25 billion and minimum 1,250 crore in India, or more than 3.75 billion and minimum 3,750 crore in India. The Indian component will not change. It will be same in individual and group. So under group, it is more than 5 billion USD and minimum 1,250 crore in India, or more than 15 billion and minimum 3,750 crore in India. Okay, and as I mentioned earlier, exclusive supply agreement in vertical anti-competitive agreement, the new term is exclusive dealing agreement. Please note the meaning remains the same. Okay, with respect to the definition or explanation of appreciable adverse effect on competition under section 3 and section 19, foreclosure of competition by hindering entry into the market is now changed. It is only foreclosure of competition. Then benefit or harm to customers. Earlier it was affecting accrual of benefit or benefit to customers. Okay. Then notice of combination, section 6 of Competition Act. After it is the earlier provision was like this: within 30 days, section 6 subsection 2, within 30 days of execution of agreement or approval of board, you have to give notice to CCI. Now it is after approval of board or execution of agreement. After any of the following means after any of this, but before consummation of combination. Okay, 30 days provision has been now omitted. Then investigation, the procedure for investigation of combination under section 29. Okay, so under section 29, if an investigation is initiated, CCI will be asking the party to, they will be issuing a show cause notice, and the parties will be required to respond within 30 days. Earlier provision was 30 days. Now it is being changed to 15 days. Okay. Then now with this is with respect to section 233 of Companies Act 2013 with respect to fast track mergers. So under fast track mergers, the merger may be between holding company, wholly owned subsidiaries, small company, and such other companies as may be prescribed, which is explained in Rule 22. That rule has certain additions now: two or more startup companies, one or more startup with one or more small company, one or more unlisted with one or more unlisted company other than Section 8. And the conditions are aggregate loan deposit not exceeding 200 crore and no default in the repayment of above. Then holding and subsidiary company, the condition is transferor not to be listed. One or more subsidiary company of holding company with one or more subsidiary of the same holding company. Transferor company should not be listed in this case. If transferor company is listed, this provision will not be, or that merger will not be going under fast track process. Okay. Then holding company incorporated outside India and its wholly owned subsidiary incorporated in India. So in India should be transferee and the other company should be transferor. Okay. Then the conditions, the provisions with respect to the contents of board's report. So the board's report, we know that it is explained in 134 subsection 3. There are certain provisions, and the last provision is such other matters as may be prescribed. The prescribed matters are included in Rule 8. So the Rule 8 has certain additions. These additions are with respect to the new e-form which has now been introduced by the government for your uploading of board's report. So it is with respect to the compliance on sexual harassment of women at workplace, Prevention, Prohibition and Redressal Act 2013 on the Internal Complaints Committee. So these provisions has to be added. One, number of complaints of sexual harassment received in the year, number of complaints disposed of during the year, number of cases pending for more than 90 days, details of application made or proceedings pending under IBC 2016 during the year along with the status at the end of the financial year, details of difference between amount of valuation done at the time of one-time settlement and at the time of taking loans from bank or FI along with the reasons thereof. Then the last provision is with respect to, not the last provision, the last addition is with respect to compliance on Maternity Benefits Act 1961. Okay, there are few amendments with respect to the e-forms as well. I have not included the same, not to make this discussion a confusing one. So the institute has released a supplementary material for your paper 13. You can just go through that. So while they are introducing that supplementary material, they will be including all the provisions. They will be including the e-forms, they will be including the filing status and all. So I have not included, I am specifically saying that I have not included those provisions not to make the discussion confusing. Okay. So you can just go through that provision, all the e-forms and all, they are mentioned in that particular supplement. Then next is the reporting process under FEMA. You know that firms portal is there, Foreign Investment Reporting and Management Systems portal there. Portal is there for FEMA reporting. All the physical activity, physical regime has now been done away. All the provisions, all the updations, all the applications shall be made through firms portal now. Okay. Then companies incorporated outside India, chapter 22 of Companies Act 2013, you know that if you are delivering any document, if you have to deliver any document to the concerned person, you have to deliver the same to registrar having jurisdiction over New Delhi. Now, with respect to the filing of e-forms, now it is changed and the documents will have to be delivered to registrar of Central Registration Center. Okay. Then political contribution. When this act was notified, when this section 182 was notified, it had the provision of maximum limit 7.5% of average net profit of preceding 3 financial years. Okay. After it, this section has undergone an amendment earlier, and this particular limit was done away, and the provision was like there is no limit for political contribution. 182 subsection 1 and subsection 3 had gone amendments 2 or 3 years back. Okay, but what happened now is that Supreme Court on 2000 Supreme Court in 2024, they reversed this amendment. Okay, so with this Supreme Court order, the limit will be the same as maximum 7.5% of average net profit of preceding 3 financial years. Please note, this is not an amendment. This is being revised or ordered by Supreme Court. Okay, yes. With respect to DIR 3 KYC, the provisions which are applicable for June 2026 examination. So you have to understand that all the amendments which are up to 30th of November 2025 will be applicable for your examination. If you are writing in June 2026, all the amendments up to November 2025, 30th November 2025 will only be applicable to you. So DIR 3 KYC provision has undergone an amendment on 31st of March 2026. Okay, so this provision is not applicable for June 2026 examination. This will be for December 2026 examination. So why I have included this provision is that if you are getting a descriptive question, you can just write this provision. Like this is an amendment in this area. So that will be an added advantage for you. Okay. So now the provision is like that if a person is holding DIN as on 31st of March, they will have to file the DIR 3 KYC on or before 30th of September, right? On 31st of March 2026, the new amendment is that if you are holding DIN as on 31st of March, you will have to file DIR 3 KYC on or before 30th June of immediately following every third consecutive financial year. And if there is changes in your DIN, email, phone number, address and all, if there is any change within 30 days, you have to file DIR 3 KYC. Okay, and a fee will be charged by the ministry. Okay, so again I am saying please note that this is not for your June examination. This is just to inform you. If you are getting a descriptive question, you can just write that. That will be a good thing for with respect to your examiner's point of view. Okay, yes. Then we can discuss the amendments which have taken place in incorporation of companies and matters incidental thereto. These amendments also had taken place some years back. Okay, this is just to benefit the old students. Okay, yes. So with respect to the small company, that is also a confusing area. On 1st of December 2025, small company has undergone an amendment. Now the threshold is 10 crore paid up and 100 crore turnover. So I was mentioning just moments before that all the amendments up to 30th November will be applicable to you. So that new amendment is not applicable for June examination. So your current threshold will be 4 crore and 40 crore for small company. Okay. And if you are getting the question, you can write this as on 1st of December 2025, this amendment has taken place and now the new threshold is like this only. With respect to resident in OPC, OPC can be now incorporated by natural person, citizen of India, it is mandatory, whether resident in India or otherwise. Resident is not mandatory. Resident means a person who has stayed in India for minimum 120 days. Conversion of OPC. Earlier for conversion, 2-year time period or crossing the threshold was required. Now it is not required. It can be converted to private or public at any point of time. Then with respect to the amendments in meetings of board and its powers, these also had taken place some years back. With respect to related party transaction, the old threshold was 100 crore or 10 percentage. Now you might be learned, or you might have learned 10 percentage threshold. New threshold. You might have learned the new threshold, but I am mentioning this one for my old students only. Okay. Then omitting of rule for changes in audit committee, nomination, remuneration committee, etc. So related party transaction, the threshold for sale, purchase, supply of goods or material 10 percentage or more of turnover, disposing, buying, selling of property 10 percentage or more of net worth, leasing of property 10 percentage or more of turnover, availing or rendering of services 10 percentage or more of turnover. Okay. Then rule 4, which was related to matters which could not be dealt through video conferencing or OAVM. After COVID-19, this rule has been omitted. There is no such provision. Rule 4 has been omitted. Then non-applicability of audit, NRC, independent directors provision and all. If an unlisted public company to which these provisions are applicable, if they are crossing the threshold or meeting the threshold of paid up 10 crore or above, turnover 100 crore or above, outstanding aggregate loan debenture deposit in excess of 50 crore, the provision of independent director, audit committee, NRC will be applicable to this company. But if these unlisted public company fails to meet any of this criteria for 3 consecutive financial years, the provision will not be applicable for the next financial year. Or you can say that this provision will not be applicable to them till it meets the criteria again. Okay. Then acceptance of deposit with respect to deposit repayment reserve and acceptance of deposit by private company. With respect to deposit repayment reserve, it is now minimum 20%. This is also an amendment which had taken place some years back. It was 15%, and it has to be maintained on before 30th of April. Private company, their limit is 100% of paid up free reserves and security premium. Okay, with respect to acceptance of deposit from members, they cannot accept deposit from public. You know that it can only be accepted by eligible public company. Good. So insolvency and bankruptcy code filing application under section 7 by financial creditors, and section 11 person who cannot initiate insolvency resolution process. So in case of financial creditors of debt or security, application shall be filed by 100 financial creditors or 10% of such creditors of the same class. This is also applicable in the case of real estate project also, allottees of real estate project also. Then person who are not entitled to make application under section 11, a corporate debtor undergoing corporate insolvency resolution process or pre-packaged insolvency resolution process. Then financial creditor, operational creditor, corporate debtor undergoing pre-packaged insolvency resolution process. Corporate debtor, in respect of him, resolution plan has been approved 12 months preceding date of application. Okay. Then laws related to SEBI. So in SEBI, there are certain amendments which had taken place in the year 2021, 24, etc. So person deemed to be connected person under prohibition of insider trading regulation, unpublished price sensitive information with respect to trading plan, person not eligible to make IPO, FPO, lock-in period of minimum promoter contribution, excess promoter contributions lock-in period, appointment of monitoring agency. In the definition or the details of persons who are deemed to be connected person, it was earlier immediate relative of connected person. Now it is only relative. Relative definition is spouse, parent of a person or spouse, then sibling of person or spouse, child of person or spouse, spouse of sibling, then spouse of child. Okay, spouse of sibling and spouse of child. Firm or its partner or employee in which connected person is partner, a person sharing household or residence with connected person. So last 2 points are now added, and earlier it was immediate relative, now it is now relative only. So unpublished price sensitive information, earlier 5 points were there. Other points are now added. 6.1, change in rating other than ESG rating, fundraising proposed to be undertaken, agreements which may impact the management or control of the company, frauds or defaults by company, promoter, director, KMP, subsidiary, arrest of these persons, whether it has occurred in India or abroad, Then resolution plan, restructuring or one-time settlement in relation to loans or borrowing from banks or financial institution, admission or winding up petition filed by party creditors or admission of application filed by corporate applicant or financial creditor for initiating CARP against the company or approval of rejection of resolution plan under IBC 2016. Initiation of forensic audit and receipt of forensic audit report. Actions initiated or orders passed within India or abroad against company, its officers like promoters, KMP, directors or subsidiary by regulatory authority, statutory authority, enforcement or judicial body. Outcome of any litigation or dispute which may have an impact on the company. Then giving guarantee indemnity, becoming surety for third party, not in the ordinary course of business, granting withdrawal, surrender, cancellation, suspension of key license or regulatory approvals. Okay. Then with respect to trading plan, earlier 4 points were there. Now it is only 2 points. And in point number 1, trading plan can be executed. It was earlier 6 months. Now it is 120 days from public disclosure of plan. And the last point is remaining. 2 trading plans cannot be overlapped. The second and third point has been omitted. Okay. Then SEBI ICDR regulation, the willful defaulter term was substituted by willful defaulter or fraudulent borrowers. Amount for general corporate purpose and unidentified purpose with respect to IPO shall not exceed 35% of amount raised by issuer. Promoters lock-in period, it was 3 years, now it is half, 18 months. Then lock-in period for amount exceeding promoters contribution, it was 1 year, now it is half, 6 months. Then if your issue size is exceeding 100 CR, bank, FI, insurance companies will be appointed as it. The earlier provision was bank or FI will be appointed as monitoring agency. Now credit rating agency will be appointed as monitoring agency, and they will have to submit report till 100% of the receipts are utilized. Earlier it was 95%. Okay. Then last is with respect to the Information Technology Act. Scheduled banks will have should be having .bank.in domain. You can check the website of any bank. Now all the banks will be having the website like HDFC Bank .bank.in, ICICI .bank.in, etc. It is to prevent the cyber frauds which are more abundant these days. Okay, so punishment for disclosure of information in breach of lawful contract, 72A, it is now only penalty up to 25 lakh. Earlier it was penalty or imprisonment or both. Now it is penalty up to rupees 25 lakh only. Okay, so these are the major amendments which are applicable for your June 2026 examination. Okay, so I think the discussion is clear to everyone. If you are having any queries, any doubts, you can ask me. Okay, and all the very best for your examination. Do well. Thank you.